Joe, guilty on manslaughter 1 and manslaughter 2. Your thoughts?
Well, you think by this time, after so many days, there would have been a chance for some type of split verdict, and we were all thinking some type of hung jury. But obviously, working through this, the jury decided that the state proved its case. It was not an accident. Rather, it was about recklessness.
Yeah, and kind of the conventional wisdom went away because, you know, when they came 2 days ago and said, hey, Your Honor, we're having trouble getting to a consensus, she reread the instructions. They also that same day said, would you please remove the gun, the zip tie that holds the gun to a box it was in, like an oversized shoebox, because they wanted to be able to hold the gun outside of the box. Those were their 2 questions. They spent the next 2 days, obviously, working through whatever it was and came to this consensus on both these charges.
Yes, and they probably were trying to determine how the gun feels and the taser feels for themselves, to hold it in their hands, which was one of the issues in the case. As well as, you know, they probably went through all of the testimony. What I do wonder is how many times did they watch the videos in the deliberations room? Because like you and I discussed before, Frank, it was quite unusual that the jury was simply allowed to have the videos and play them at will whenever they liked in the deliberation room. Yeah,
I'm not sure people understand how odd that is for a criminal case. Usually there is no transcript of what word for word everyone said. The judge's instructions are, hey, you need to rely on your memory and best recollection. And that came up as the very first question they asked. They came back and said, at what date did Kim Potter speak to Dr. Miller? Dr. Miller was the psychologist who testified about action error, this thought that you're doing one thing and doing the other in relation to the gun and the taser. But they asked that question. That was their very first question, Joe, and she said, hey, rely on your memory. But no memory needed. I mean, they had every video they wanted, and they could play it back, whether those videos were in real time or whether they were some of the very slowed down videos. That's unusual.
It's very unusual. In 98% of the cases, what happens is if the jury wants to watch the video again or hear an audio again, they alert the judge, and everyone goes back into the open courtroom, and usually a law clerk or a bailiff will play that video for the whole courtroom to see from start to finish. Rarely do we ever see that a jury is allowed to just simply watch the videos. But the defense agreed to that in this case, so there you have it.
She went straight to jail. She will spend her Christmas Eve and Christmas in jail, a woman who has served for 26 years as a police officer. Joe, they made some arguments to get that to happen, but that is certainly rare. But let's talk a little bit about sentencing. What could Kim Potter face for manslaughter 1 and manslaughter 2 in the state of Minnesota?
Well, a few things. First, being taken into custody after a conviction on a matter that could put you in prison, that prison is called for, is not unusual. All judges do that. If you're facing 4, 10, 15 years in prison and you're convicted, you do go to jail. So that's not unusual. Second, in terms of the charges, for count 1, first-degree manslaughter, it's 86 months in prison. For count 2, which is second-degree manslaughter, it's 48 months in prison. However, lastly, the prosecution wants to get a greater sentence. That's what they talked about with the whole Blakely issue. Blakely being after a United States Supreme Court case, Blakely v. Washington in 2004. So that's what they were talking about. They'll hash that out from now till sentencing.
Yeah, so as it stands right now, the minimum's call for 12 years, but they're going to go ahead and say, had you not shot Dante Wright, he wouldn't have driven off. And by him driving off, he hit this other elderly couple named the Lundgrens, and that led to not only destroying their car, but Mr. Lundgren having a lot of health issues. And the other thing they'll argue, I think, Joe, is hey, you're a peace officer. They're aggravating circumstances. The penalty should be even stiffer for you. So that's on one side. Do they not take in her record, her life into account as well, in terms of the fact that she has been, for all intents and purposes, a good cop up until this moment, Joe?
Yes, you heard Mr. Gray say at the end that they, or Mr. Eng, that they would be going for a dispositional departure. So you get 86 months on the top count, which is about, 8 years. What the defense team is going to be arguing is no Blakely issues, meaning no reason to enhance the sentence, but then ask for a departure, meaning that they don't want prison at all. Rather, they're going to be requesting the judge to put Ms. Potter on probation.
I can't imagine in this climate that's even something she could consider, is it?
Oh, the judge will consider it. I mean, she has to. The defense will make motions. She'll consider the memorandum. She'll consider the argument. Is it likely? No. In these situations, it's unlikely. I mean, we could go back years ago, like with the Amy Sensor case. She was convicted of second-degree manslaughter for leaving the scene of the accident and killing someone. And they made motions for a departure, but the judge sentenced her, as the guidelines call for, 48 months.
Yeah. So if she does get at least 12 years, it's my understanding, Joe, in Minnesota you need to serve at least 2/3 of that before you can be paroled or be considered to serve your sentence outside of jail, outside of prison.
That's correct. So just take an easy number. If you got a 6-year sentence, you serve 4 years.
Oh, so it could look at that. So, Joe, anything else surprise you? I know we've had so many surprises and twists and turns in this case. This all appeared very straightforward today, the verdict phase.
Yes, I mean, the verdict was straightforward. The only thing that surprised me in the case was basically when Ms. Potter testified. She testified last, which I still question. We discussed that before. As well as the jury had that issue of what did she say or when did she say it to her expert, Dr. Miller. So, and remember, what she supposedly said to Dr. Miller was that she saw a gun in her hand. And as you and I have discussed, we always thought that was consequential, but there was never an explanation given by the defense for that. So that still sticks in my mind.
Joe, I never asked you, but I've thought about it. Why is that conversation she had with Dr. Miller public knowledge? Why isn't it just I'm talking to this psychologist? Is it because he testified? All that had to be on the record? I mean, can she not? She couldn't have had a conversation with her therapist or with this doctor without having that be in the record?
Because he testified. He was the expert. He took what she said, as well as all of his expertise, and developed an opinion, and that's what he gave on the stand. But by having Ms. Potter testify last, remember, the expert wasn't able to see her testimony. Dr. Miller even stated on the stand, well, I haven't heard her testify. Because obviously he testified before her. So when your expert, your doctor, your therapist, whoever it may be, gets on the stand as a witness for you, yes, whatever you have told them will be admissible.
The defense wanted to get in all this prior information about Daunte Wright in terms of arrests, the fact that he's missed 5 court dates, some other run-ins having to do with a gun in the Minneapolis police. Does any of that play into the sentencing part, Joe?
No, because what would happen is if the defendant knew of all those things, it would have been admissible in court. Since it was not admissible, it will not come into play in question. Okay. Yes, the judge will consider the factors surrounding the defendant, the factors surrounding the victim's family, but as to whether or not Mr. Wright had whatever type of record or relationship with the police, that won't be considered.